She should be able to now.
Okay. Commissioner Leclerc, can you hear us?
Yes, I can.
Awesome. All right, we'll get started. Welcome to the October 25th meeting of the Maine Commission on Governmental Ethics and Election Practices. We're here today to consider several matters, and we'll get started with the ratification of the meeting minutes from the August 23rd, 2023 meeting. Does anybody have a motion?
I move to accept as presented.
Is there a second? Is there discussion? Okay, hearing no discussion, we'll proceed to a vote. Commissioner Newman?
Yes.
Commissioner Marvel? Yes. Commissioner Hastings?
Yes.
Commissioner Leclerc?
Yes.
And I'll vote yes as well. Moving on to agenda item 2, it's a request for an investigation of the Honorable Troy D. Jackson. And our normal procedure for this is to have Mr. Wayne, the executive director, brief us on the background of the investigation of the case, and then we'll hear from the proponents of the matter, and then we'll hear from the respondents. So, Mr. Wayne.
Sure. State Senator Troy Jackson is in his 4th consecutive term as a state senator, representing Senate District 1, which is northern Aroostook County. And he's also the president of the Maine Senate. His home is in Allagash, Maine, and the one-way drive from Augusta to Allagash is about 300 miles. It takes about 5 hours. On August 29th, we received a complaint from State Representative John Andrews. He asked us, really it's more of a request for an investigation than a complaint. And he's asking the commission to investigate whether Senator Jackson had submitted false information in his filings to the commission and whether he may have violated the requirement that state senators reside in their district. The reason for the request is that Senator Jackson in 2019, in September, he and his partner purchased a property in Augusta, and they owned it for a little more than 2 years, and they sold it in December 2021. And as part of that transaction, they received a mortgage from a private lender that was insured by the Federal Housing Authority. And the security instrument that they signed contained a number of covenants or promises. And one of the covenants was that Senator Jackson would use the property as his principal residence for at least 1 year. And the FHA defines principal residence as a property that will be occupied by the borrower for the majority of the calendar year. So in effect, Senator Jackson and his partner were promising that once they began occupying the property, in the next year, they would occupy it for the majority of the year, and any remaining part, they could live somewhere else. So the question that's raised in the request is, if Senator Jackson is promised for a year to make this his principal residence, may he also be a resident of State Senate District 1 for purposes of serving in the legislature? And Senator Jackson is here with a legal advisor. I'll let them speak, but basically he explains in his response that this was purchased as a temporary place for him to stay so that he could carry out his duties in Augusta as a state senator and also as the president of the Maine Senate. And there's an announcement in the memo, which I could go into, but I think you'd probably rather hear from the parties.
Okay, very good, very good. I do want to make sure that everybody understands before we get started that our jurisdiction in this is limited to the legal or the legislative ethics questions and the questions of campaign finance and running a campaign. We are not charged with authority to examine whether or not a senator is properly a member of the Senate, because only the Senate is the judge of the qualifications of its members. So I'd encourage the people testifying, I'd encourage the commissioners to keep that in mind as we're evaluating the evidence. Representative Andrews, are you here?
I am.
Terrific. Could you come up to the witness chair and brief us about your complaint?
Sure. Good morning, everybody. My name is John Andrews, and I represent House District 79 in the legislature. As a member of the Judiciary and Veterans and Legal Affairs Committee, I filed the complaint that you are hearing today regarding Troy Jackson's federal declaration that he lives in Augusta while representing the state's northernmost Senate district. This is an incongruence that needs to be looked at in depth, and I am hopeful that you approach today with an open mind, a hunger for justice, and objectivity towards the name the complaint is against. Writing off this complaint because it is against the sitting Senate president is a disservice to the citizens of Maine. There have already been attempts in the press to write this off and instruct people that there is nothing to see here. Last week, the BDN ran a story saying that this issue was settled, that Troy Jackson had done nothing wrong, and that it was time to move along. Even Maine Public finally covered this story for the first time when it looked like the coast was clear for the Senate's top appropriator of public funds. I had people contact me asking how this was possible if the Ethics Commission hadn't even met yet. And I told them that that was a very good question. I find it both amusing and sad that we are meeting in the Pretty Flaherty building to discuss the alleged wrongdoing of Troy Jackson. Pretty Flaherty is not only the biggest lobbying firm in the state, but they have also represented the Senate president in his real estate war against the elderly couple who sold him the Augusta home in question. That seems like extremely small ball with a negligible profit motive for such a large firm, unless they were giving legal advice and representation to the state's most powerful legislator for another reason. If any of those billable hours were pro bono, would they need to be reported on a statement of income form? Yet another question to be asked and answered through an investigation. The Augusta home in question is the home that Troy Jackson legally declared in writing in front of a notary would be his principal residence for 1 year to obtain a federal housing authority loan. He signed this declaration while serving as senator from Allagash, a district hundreds of miles away from what would be his federally recognized principal legal residence. To be the senator from Allagash, he must fulfill the state's constitutional residency requirement. Both of these things cannot be true at the same time. You must look into these conflicting propositions. I would also ask you to look into why Troy Jackson's reimbursements have gone up every year he's been Senate president, especially after he declared his principal residence to be in Augusta. If he lives in Augusta, as he declared on the FHA loan, why have Maine taxpayers reimbursed him over $82,000 over the course of 2020, 21, and 2022? Of note here is that the Maine legislature was shut down for COVID during part of this time. Another interesting fact is the person who signed off on these reimbursements was Troy Jackson as a presiding officer. Troy Jackson also passed joint rules to allow himself to approve his own reimbursements with no need for receipts. This is not a best practice that should be fixed. People have lost faith in their government and institutions. The Ethics Commission, the People's Watchdogs, has an opportunity today to restore a little bit of that faith by doing their due diligence, their due investigative diligence, and not writing off this complaint as partisan politics. There are facts and reimbursement funds that paint a picture that at the very least is worth taking the time to do the due diligence and investigation. If you find through investigation that parts of this complaint, notably mortgage and insurance fraud, are out of your purview, then that's fair play. If that happens, then I would ask you as a commission to contact U.S. Attorney Darcy McCulway's office and ask them to investigate the things that you cannot. We cannot allow corruption to slip through the cracks of bureaucracy. I thank you for your time and ask you to please investigate these serious issues to help restore the people's trust in their government and its watchdogs. Thank you for your time.
Thank you, Representative Andrews. I can assure you that we'll be thorough and we'll be objective. That's the nature of this board, and we take our job very seriously.
I'd expect nothing less.
Does anybody have any questions for Representative Andrews? Any commissioners? Commissioner Leclerc?
No, thank you.
Are there any other proponents? Well, I do have a question for you. Do you have any evidence other than the agreement to buy the house and the requirement, the federal requirement to reside in the house in Augusta that demonstrates that the senator was not residing as it's described in Maine statute in Allagash?
I think the signature on an FHA loan is declaring in front of the federal government that your principal residence is in Augusta. And that cannot be in congruence with being the senator of the northernmost district of the state. I believe that those two cannot be true at the same time. And I think that is worthy of an investigation of this committee to determine which one has precedence. The state's residency requirement or signing your name under a notary that you principally live in the capital of the state.
Mr. Bolton, could you just lead a brief discussion on the residency requirements in Maine?
Sure. Residency for purposes of being a candidate, I think have generally been equated with the same residency requirement for being a voter of a particular district. So the same, at least in Office of Attorney General opinions in the past, the same standard is basically applied. And you look at, it's a combination of a person's intent to return to a particular place, plus objective indications of residency. So, things like where your car is registered, where you, where your driver's license says your registration, various objective indicators of residence. So you combine those two things together. So it's not an exact science. I think some of the AG opinions have talked about that, and you really have to look at different factors, and you put together a picture. And I'll point out too, there is a process when a candidate registers to run for office that the Secretary of State administers, where a person can challenge a candidate's qualifications for office, including a residency. And if that happens, there would be a proceeding to look at those factors and determine whether the person's qualified or not to run that district. That did not happen in this case. There was no challenge.
And the Secretary of State would run that?
Correct. It would be an adjudicatory proceeding run by the Secretary of State. And basically what happens is the candidate files what's called the consent form. And part of the consent form where you're consenting to be a candidate is you have to certify that you meet the qualifications for office, which include being a resident of the district.
Okay, very good. Yes, Representative.
I'd just like to point out that somebody purchasing a house in Augusta is more than fine. Signing your name on an FHA loan is a completely different animal, and that's not okay. Thanks.
I understand. Is there anybody else you have here who'd like to speak in favor of this investigation?
I'm just speaking on my own.
Okay.
Sorry,
Yeah. Commissioner Hastings.
Representative Andrews, I'm hearing the difference between residency for holding office and the requirement of the mortgage are somewhat different, weren't they?
I believe that's what needs to be investigated.
Are you suggesting that Senator Jackson did not also maintain a home in Allagash?
I'm saying he signed his name, his principal residence is in Augusta, and that's not in congruence with the residency requirements.
So you're
And furthermore,
sure
if
it's the fact that he signed that mortgage.
furthermore, if his principal residence was in Augusta, why have his reimbursements gone up progressively every year that he's lived in that domicile? There's enough pieces here that are worthy of investigation, in my opinion.
Well, I think I want to make it clear that our investigation is focusing on the fact of the senator's residence, where he in fact resides for the purposes of election law, not any assertions or representations that he's made to another agency. So we are looking at the factors that Mr. Bolton described to determine whether in fact he was a resident of Allagash during the time in question. We're not, I mean, the fact that he has represented somewhere else, that he resides somewhere else is one factor that we would certainly take into account, but our job is to evaluate whether or not he was in fact a resident of Allagash during the time in question. Just, I wanted to make that clear to you.
Thank you.
Sure. Anything else?
No, sir.
Okay. Representative or Senator Jackson, would you like to speak? Okay. Please introduce yourself and your companion.
Good morning, everyone. I'm Senator Troy Jackson. I represent Senate District 1, Northern Mercer County. I reside in the town of Allagash, and I have the honor and privilege of being the Senate President. I asked my friend that I've gotten to know during apportionment, Don Alexander, who has actually dealt with this in the past in his professional role, to come and help me with this. And that's why he's here today, and I appreciate Judge Alexander being willing to be here and stand with me on this issue. I just wanted to say that I am very thankful that you've taken this up. I'm sorry that you had to deal with it. I lifelong resident of Mercer County. This is going to be my 20th year in the legislature. Some of you served with in some role, I take this job very seriously. The reason why I got into politics, not being at all political, actually quite naive in the beginning, maybe still now, is because I thought my area needed representation down here in Augusta, and I've really strived to do that. Allagash is my home. It's where I vote. It's where my parents grew up, it's where my grandparents grew up, where my children grew up. It's where I'm going to go back. Whatever happens in the future, that's always going to be home to me, and I've never shied away from that. And it's something that throughout the period that I owned that home, I was clear with people that Allagash was my home and will continue to be my home. I again, doing this job as a state senator or House rep before is a privilege and something that I take, like I said, very seriously. And, people deserve to be represented. And if you're not gonna be here, if you're not gonna show up, then I don't think you should be in this job. That's the whole basis of why somebody should run. I have, close to 100% voting record for year after year, which a lot of people in the state legislature can't say, including people in this room. I show up because that's what the job is about. And, I wanted to just be sure that people understood that, I purchased the home because rates went up here. It's not easy to find a long-term place to stay. I do feel very strongly, being the Senate President, that I have to be here. It's not only for the legislative session, but it's for, around the session. That's how I actually started to work with Judge Alexander, was on apportionment, which was very protracted in the off session. Myself and whoever the speaker is basically the employers for 400 to 500 people over the state legislature, and there's things that come up all the time that has to be dealt with. I make sure that I'm available because that's what my caucus members and the entire state Senate voted me to do. The place in question, I'm really extremely sorry that I ever purchased it because of all the trouble that we had with it. But that was never, you know, where I consider my residence. When we had the discussion about the loan, and this is the first home I'd ever bought, you know, I hired a realtor. The realtor advised that I should get a mortgage broker. I went to the mortgage broker and talked about it. He recommended this loan, and it's been reported in the media in a way that, you know, I tried to push the blame onto him. That was never the case. In the end, you know, whenever I sign something, that's you know what I should be. But the conversation we had was, where do you spend the majority of your time? And I said Augusta, and that is accurate. I mean, my residence is in Allagash, but we just came through an 8-month session. I mean, how could anyone say that I didn't spend the majority of my time in Augusta? I mean, that's the fact of the matter. And before I was Senate President, you know, I came down Sunday nights, went home on Friday, went home on Saturday. You know, this past week, I made 3 trips to Augusta County. So, I mean, I don't know what else to say. I mean, that's the job, and I feel very strongly about it, and I'm actually quite concerned how this is gonna play out for rural legislators. You know, are we not supposed to be down here doing our job, representing our area? I mean, there's all kinds of people that has to stay here during the week. There's all kinds of people that have apartments. I've known people that pass their own homes. And I never thought twice about that, because it's a real challenge to find a place to stay and try and live out of your suitcase like that. So, and in the end, you know, I'm sorry that this is going on, because I don't think it makes the institution better. It's unfortunate that these, you know, Washington DC type of attacks are coming here to Maine. I do think people lose faith in their government, but I think they lose faith in their government because of complaints like this that in the end, I don't believe have any basis. I'm happy to discuss it. I'm happy to talk about it. If you choose to investigate it, I'm happy for that too, because I don't feel like I did anything wrong. And at all times, I was trying to represent the people that I were elected to, and in my role as Senate President, the entire state.
Thank you very much.
Could I add one slight thing?
Absolutely.
Is if you look at the law, and the residence of the person for a legislative district thing is a place, principal home to which the person, whenever temporarily absent, intends to return. There was no question when Senator Jackson applied for the loan that the people taking the loan application knew he was a senator, knew his principal residence as defined in the law was in Allagash. And also that when he applied for it, and when the term, you know, primary residence in the loan application was there, he in fact, the majority of his time was here. So that was a correct statement. Had he said that the Augusta home was not his primary residence in the loan application, that might have been not a true statement, because as you pointed out, particularly in the first sessions of the legislature, but you have to be there, basically, member, you folks have done it. It starts in December. It ends, if you're lucky, in the end of June, but mostly it goes into July. In 2001, basically the legislature was continually active because of the apportionment process and several other investigations going on until the end of September. So from the December of 2020 to September, and it was the end of September, it was September 28th, I think the session was, that approved the apportionment. The legislature basically was continually active. There were a lot of people around here in the summer of 2021 to do it. It was his principal residence. Had he said something different, that might have been untrue under the mortgage law. I just wanted to add that sort of as a legal point. The difference in the law between what the requirement of statute is, the homeowners tend to return, and the mortgage requirement, where you're going to spend the majority of the time. And remember, the mortgage people knew he was a senator representing Augusta. Thank you.
Thank you very much. Senator, I have a couple of questions. Your home at 167 Allagash Road, is that a single-family house? Is that an apartment?
It is a single family, two-story colonial, me and my wife. Well, we were lucky, her father gave us 4 acres of land, and we had it's a modular home, so we had it installed in 2005.
And you own it?
Yes.
The other question is, during the period of time at issue, that several year period, were you a clean election candidate?
I've been a clean election candidate since '05. So, yeah.
That's just to establish whether we have jurisdiction over those financial issues.
I definitely have, throughout the period you're questioning, definitely I've been a clean election candidate.
Did you hear Mr. Bolton's description of the factors that go into determining residency? Part of it is intention to return after an absence, but there were a number of other things, where your car is registered, where you vote, where you pay your taxes. Could you address those?
Sure. Everything, I have as 167 Allagash Road, as far as my license, my hunting license, my fishing license. I received my homestead exemption in Allagash. At no time did I ask for the homestead exemption down here in Augusta. When I filed, after we sold the house, I paid capital gains down here because it was my second home, wasn't my primary home. Everything that I have points to Allagash as being my home is why I intended it. And there's never been a question. I mean, I'm proud of being from Mercer County. I'm proud of being from Allagash, and I'm going to continue that's going to be my home. And this. I don't know, people trying to make, this was not, this loan was not like a great thing or anything like that. It was a loan that fit at the time, but I really, the fact that the standard was, where do you spend the majority of your time, was fine. But like I said, I don't even feel like I got any extra special deal on this. It was just a loan that worked at our income level, and that's why we went forward with it. But it's been more of a hassle than it actually been a gain. So,
okay. Any commissioners have questions for Senator Jackson? Commissioner Leclerc?
Well, I'm just kind of looking at, there's been no action started by FHA in this case, right?
I do not know. Mr. Wayne, do you know?
Not that I know
Okay, thank you.
Commissioner Hastings?
I guess I'd like clarification. Wayne, Mr. Bolton, exactly what alleged violation of our ethics committee jurisdiction are before us right now. I mean, there've been all kinds of allegations. I don't know if they all come within the purview of the ethics commission's jurisdiction.
Well, do you want to pick up?
Don't, please.
And you may want to get more definition on that from Representative Andrews. The request says filing of false information with the commission. I had a subsequent, first I asked him for more in writing to flesh that out, and then I had a subsequent conversation with him in the office. So I felt like I got a handle on it. I think false information would be the addresses that he has used in filings with our office. And I looked at the time period that was relevant when he owned both properties, and it seemed to me that I should be focusing on his 2020 campaign. So in that, because that's the only campaign that he ran when he had both properties.
As a clean election candidate.
As a clean election candidate. So I focused my attention in the memo on his filing of a candidate registration statement in January of 2020. And on that registration, he listed 167 Allagash Road in Allagash. So the way I was approaching it, which doesn't have to be the way you approach it, is that a false address? And on that basis, I didn't think that the request provides grounds for believing that a violation of that registration statute occurred. Let me just add that I've heard remarks of disappointment with the staff memo, that they'd like to see and expect more of a scope of effort by the commission.
From whom?
From our whole office, but they were disappointed that I was looking really only at campaign finance. And I should have said at the outset, the staff is happy to do whatever kind of investigation you want. There's no reluctance on our part to do any investigation. It's not a problem, but we tend to be cautious in terms of looking at our authority. We don't want to end up being some sort of roving inspector general of the entire legislature. We want to look at what are those zones of behavior that we're asked to look at and stay within those. So.
Right, that's why I started out by saying that we're concerned specifically with legislative ethics and campaign activities and campaign finance, and not with qualification to be a senator. And I thought about this question a little bit too, and I think some potential things that we could be looking into are obtaining contributions, clean election contributions through deception. I think that would be within our purview. Seed money contributions or something based upon where someone is trying to represent in the legislature. I think, as you said, false statements on campaign forms. Please.
Part of Representative Andrews' presentation dealt with reimbursements to Senator Jackson through the normal system that all legislators apply for reimbursement for travel and the like. Is that anything that is even within our jurisdiction?
Not as far as I'm concerned. We're authorized to investigate violations of legislative ethics, and that phrase is a defined term, Title I, and it refers to certain categories of misconduct, like voting in a conflict of interest or unduly influencing an administrative agency, or there's certain acts of official misconduct that we are directed to investigate, but they don't include anything having to do with reimbursements by the legislature or any kind of personnel matter relating to the legislature. Those aren't among the list of topics that we're directed to investigate. So, like I said, we have always taken a sort of a cautious view of our jurisdiction. We get complaints from people who say, that's unethical relating to legislative conduct. And if it doesn't fit into those categories, our view is we're not to investigate those.
And those are categories that are spelled out in the statute.
Correct.
Does that answer
I guess it does.
Just to be direct, there's no suggestion that a legislator's reimbursement for their travel is one of the topics that we're directed to investigate. Okay, so I think the answer is no.
Okay. Senator Jackson.
Yeah, well, certainly since it's been brought up, I'd like to just respond to that. Representative Andrews not being in Maine that awful long, he probably has not been to Allagash, but it is, depending on which way you go, on average 300-mile trip. It takes me 5 hours. I've had trips that took me as long as 11 hours to get home during a snowstorm. It's no picnic to go back and forth like that, but the belief or the accusation about signing off on your own, that has been the system since I was in the legislature. Before I was in leadership, leaders signed off on my expense reports, and since I became leadership, that's the system that I was under. I didn't create that or anything like that. The same thing for Senator Stewart. He signs on his. Senator Kime, Speaker. I don't have any problem with that. It's been very clear. During the 2020 campaign, I told people I had a house over here. Secretary Priest lives right up the road from me. She would go by it every day. Now I tell people I have an apartment up here, not trying to hide it or anything. But that being said, I do go home all the time. Oftentimes I don't get paid. Well, not oftentimes. Sometimes I don't get paid because you only get one trip. But I mean, I go home all the time. I can't go home enough. I missed my whole fishing season this year because we were in till, August, which is fine. It's part of the job. But I wish people would be able to understand the amount of vehicles I've gone through, the repair, the tires. I mean, there's people can say whatever they want, but I am not making money off the expense because there's just no way that it keeps up with what it actually costs you to travel, 45,000 miles a year.
Any other questions from commissioners? Commissioner Leclerc?
No, thanks.
Okay. Are there any other folks here who would like to speak on behalf of the respondent? Okay, seeing none. Thank you very much.
Thank you, appreciate it.
Appreciate it.
Yes.
I'm not really intending to speak on either on behalf or against the respondent, but a couple of comments that.
Okay, come on over to the witness chair.
Before anybody gets scared, this is just what I picked up off the speech.
I wasn't the least bit scared. And introduce yourself and tell us what you'd like to say.
Hi, my name is Wayne Clardy. Been here before a few times. I don't really have too much to add except just a couple of points that I had noticed when the publicity first came up about this that might be pertinent. I believe it was Mr. Hastings asked if there was any other indications where Senator Jackson had indicated a address other than Allagash. When he sold the property in Augusta, I believe the transfer of deed listed the owners selling the property as Senator Jackson and his partner of that address in Augusta, not the Allagash address. That said, that could be where somebody else filled out the paperwork, but that is one other indication where the paperwork was done wrong, apparently, at least for Senator Jackson's testimony. But one other fact that Mr. Bolton said there were many conditions for weighing residency for voting purposes. If you check, I think it's section 121 of Title 21A, that actually establishes the registrar in the municipality as the exclusive authority in deciding residency for voting, which I would think would indicate that for any determination whether Senator Jackson was a resident of Allagash in terms of being qualified as a candidate for NCAA funding, you would have to defer to the decision made by the registrar of the municipality.
That's not my understanding, Mr. Bolton.
It's correct that when you're registering to vote, that the registrar is the sole decider of residency. I would not read that statute to make the registrar's determination binding as a matter of whether somebody's qualified to serve or not. I don't think the registrar's power extends that far, and I think our office has opined in the past that where you have successfully registered to vote is not necessarily a residence for qualification purposes, although it's a factor to be considered.
And I think the commission is perfectly capable of determining a residence question.
Realize that, but that is at least if you're defining it in terms of is a candidate qualified and it's being dependent upon, are they a resident for purposes of voting in that district? That would be a pertinent consideration.
If that was the question, we would ask the registrar.
Yeah. Okay. That was the only other aspect. The other thing is Senator Jackson. I know.
Address your remarks to us, please.
As far as Senator Jackson being an inheritant of the travel reimbursement fund, which admittedly is not part of this hearing. I think you would probably be well advised to consider restructuring it so that there are safeguards in place so that he's not faced with the appearance of a conflict of interest on approving that. But that's all I had to offer to the commission.
Thank you. Any commissioners have questions for Mr. Carter? Commissioner Leclerc?
No, thank you.
Okay, thank you very much. Are there any other people here who would like to testify on behalf of the respondent? Okay, would someone like to make a motion in this matter?
I move that no further investigation needs to take place.
Is there- Okay, it's been moved and seconded that we take no further action on this matter. Is there discussion?
Yeah, I'll say, I mean, I think that there's a lot of conflating of principles here. The fact that Senator Jackson's principal residence, as he indicated apparently on the FHA, I'm going to accept all these facts as true, doesn't negate the fact that Allagash could still be his residence for the purpose of reporting and being the district he's from. As I understand it, and as Attorney Bolton has advised, you can be temporarily a resident. There's no definition in statute or otherwise that limits the space of temporary. So, for example, for the FHA loan, you have to have as I understand it from the documents, your principal residence for the majority of the year. That can still be a temporary relocation. So I've seen nothing that indicates anything untoward and any need for further investigation.
Any other comments from commissioners? Commissioner Hastings?
I guess one comment. The job of president of the Senate is a bigger job than being a representative or a senator. From my experience, the members who are in leadership, especially the president and the speaker, to do the job well, it's very close to a full-time job. So I find it very credible that Senator Jackson would have been in Augusta for the majority of the year in question as the president of the Senate. And that is not inconsistent with him remaining a legal resident of Allagash, which I quite I think Allagash is near and dear to Senator Jackson's heart. One factor that he pointed out, if he had treated the Augusta home as his personal residence, when he sold it, he would have been able to claim it as a personal residence and have avoided capital gains tax. He says he indicated that he did not do that. That's a pretty strong indication against interest, if you will, there. So I support your motion.
And I also want to say, I think the statute is clear, but I can't imagine that the statutes were drafted in a way that would make it more difficult for rural members to have representation and very active representation in Augusta. And I think, I think the statute's clear and we don't necessarily need to consider statutory interpretation, but I wouldn't think this commission would want to make it more difficult for residents of rural districts to be in Augusta. And this could be taken far enough that potentially you could have there could be no residents of rural districts in particular that we're able to serve because they need to be in Augusta so much for the job. So it's another factor that I do think we should keep in mind.
Any other comments from commissioners or Commissioner Leclerc, anything?
Just briefly, I'm very well aware of the effort that it takes Senator Jackson or anybody from Aroostook County to make it down to Augusta on a regular basis. And the rules regarding the FHA loan, are separate from what we have to consider here today, but I would note that those rules are pretty much designed to prevent people from buying multiple houses to rent out and use for investments and stuff like that. It's pretty clear that Senator Jackson absolutely needs a place to stay when he goes to Augusta, and that he spent an enormous amount of time in Augusta. But I don't question at all his dedication and residence in Allagash. So I would support the motion.
Thank you. Any other? Yes, Commissioner Romero.
Yeah, I would just briefly say that I'm comfortable and glad actually to listen to the motion and some of the comments of the other commissioners. I'm not going to judge the motivation behind the request for investigation, but it seems to me at multiple levels that that's really, the issue at hand is not within our purview. And if the concern was a misstatement of fact on an application for a loan, then there are other parties to look into that. I think more suited for the matter. I'm almost a little chagrined that this matter has come to us, but I agree with the motion and will support it on vote.
And I'd just like to say that I appreciate everybody who came and testified here today. And I think, as Commissioner Newman said, we can take everything everybody said as fact. Representative Andrews, everything you said, I believe. Senator Jackson, everything you said, I believe. And I, in evaluating the evidence that's been presented to us and our jurisdiction in the matter, I conclude that you are a resident for purposes of state of Maine law and the areas that we're supervising of Allagash. And you know, as other people have said, there are several different standards at work here, but the standard that we're evaluating is whether under state law you're a resident of Allagash for purposes of legal ethics and campaign finance and conduct of the campaign. So I support the motion as well. Is there any further discussion? Okay, it's been moved and seconded that we take no further action on this matter. We'll move to a vote. Commissioner Newman?
Yes.
Commissioner Marble?
Yes.
Commissioner Hastings?
Yes.
Commissioner Leclerc?
Yes.
And I'll vote yes as well. Thank you very much. Let's move on to agenda item 3, a complaint about a flyer in House District 52.
Thank you very much.
Sure.
Thank you.
Thank you. Mr. Wayne.
Sure. Item number 3 is a request for an investigation from Jennifer Small, who's a resident of House District 52. I believe she's not participating here today, but she wanted to request investigation about a flyer that she found troubling that was distributed in mailboxes in that district in October of 2022. The flyer came within another publication that was styled as a newspaper, and I have a copy if you want to see the newspaper. It has newspaper format, but it's not a conventional newspaper. And her belief is that it was sent through the mail.
I think we have a copy in our packet.
Oh, do you? Okay. Well, I know we gave you the flyer in color, and that's really what the issue is about. The flyer contains negative statements about the Democratic nominee in that district, about how she's dangerous for kids, and addresses social issues like children's books and COVID. And so from our point of view as commission staff, since this was distributed close to the election, and it does mention a candidate, it has a couple of potential issues with it. One of them is that it says paid for by concerned parents of MSAD 75. And what really is required is that the name of the person and the address of the person who made or financed the expenditure be identified. And we don't really know who concerned parents of MSA D75 is. We don't know if they're a person, and there certainly is no address. And then the other critical information that is not on the flyer is it's supposed to include a statement of whether or not it was authorized by a candidate or the candidate's political committee. So on its face, there seems to be a violation of that disclaimer statute. It possibly is an independent expenditure that needs to be reported if it costs more than $250, and if it was done independently of any any candidate's campaign, then we should have gotten a report for it. So on the whole, commission staff sees some merit in conducting an investigation. We thought you would probably want us to investigate. We feel it's regrettable that it came to our attention 10 months after the fact. And it could be one of those investigations where it's hard to tell who's responsible. And so it could, after a while, be a case of diminishing returns. But we're happy to embark on it and try to determine if there are any violations.
Terrific, thank you. Any questions for Mr. Lane from the commissioners? Commissioner Leclerc?
I'm sorry, I wasn't raising my hand.
I just want to, you're not on the display
Yeah.
most of the time, so I just want to make sure we're not missing you.
Oh, okay. Thank you. I appreciate your efforts. Thank you. I'll shout.
Excellent, excellent. Okay, so is Ms. Small here? She's not here? Is there anyone else who is involved in making a complaint? Okay, is Representative Cluchey here? Okay, so do we have a motion in this matter?
I move that the commission conduct an investigation into the matter.
Is there a second?
Second.
Okay, it's been moved and seconded that we conduct an investigation. Is there discussion amongst the members?
For the reasons that in the staff memo, I
Yeah.
think it is appropriate that we conduct an investigation.
No, it seems pretty straightforward to at least open an investigation. There's a candidate named. There are comments made about that candidate. It was in the time frame of an election. And we can guesstimate that it had a cost that hits the threshold of possibly being an independent expenditure or something affiliated with a campaign, which we don't know. I don't know, and I'll look forward to staff recommendations. If partly due to the time that's passed, it's a lot of trouble to figure out who did what when, but I think we would be abrogating responsibility if we didn't at least try to look into it.
Credible complaint is the list.
Yeah.
Mr. Bolt, can you address briefly the standard for conducting an investigation?
Sure. Let me just bring up the statute so I give you exact language. So the standard is that you shall make the investigation if the reasons stated in the request so show sufficient grounds for believing that a violation may have occurred. And I think it's, you know, it's fairly straightforward. If you look at the evidence, there's probably some threshold for that may. But if you think, if you think there's a reasonable possibility of a violation, I think an investigation is warranted under the statute.
And I think this complaint meets that standard. So I support the motion. Any further discussion? Oh, yes, please.
Yep.
Yep.
Hello. I would just say that I mean, I can understand, you know, people doing this, you know, getting who have strong interests in elections, and so want to participate in this way, exercising, you know, their right to free speech. And this might, pursuing this may enable us to educate the public about, you know, these fairly simple rules that need to be followed when this sort of material is distributed, so that the public knows where it's coming from. So I think for that reason too, it's a proper use of our resources.
I appreciate that comment, and the similar situations have come up several times in the past, so I think it'll be, anytime we can educate folks more about the campaign requirements, I think that's useful.
Yeah, I think we had a case where somebody made signs and, and
Right.
it's perfectly understandable that people would want to do this. And the rules that we ask people to follow are not that complex. So it might be a good educational use too of the commission's time.
I agree. Any other comments or questions? Okay, we'll move on to a vote. It's been moved and seconded that we conduct an investigation in this matter. Commissioner Newman,
Yes.
Commissioner Marvel,
Yes.
Commissioner Hazelton,
Yes.
Commissioner Leclerc,
Yes.
and I'll vote yes as well. Thank you. And having reached our natural point for a break, I think we'll take let's take about a 10-minute break. Come back at 5 after 10.
A second.
Sarah, can you hear us?
Yes, I can.
Outstanding. All
Can
right,
you
let's,
Never mind.
I can, perfectly.
Okay.
Okay, let's come back into session. I apologize for the lengthy break, but we had a couple of legal questions to discuss. The next item is agenda item 4, which is proposed rulemaking. Mr. Wing?
Sure, this is a continuation of a rulemaking that we proposed at your last meeting. And some questions came up regarding one of the subsections of the rules. So we took another stab at it to try to get at something that the commissioners might like. I can walk you through the changes, or you've already had a chance to look at them and maybe you just want to proceed to comments.
Can you do just a very brief visit on each of the changes that we're talking about?
Sure. So the changes relate to chapter 1, section 10, subsection 5. So it's page 5 of the chapter 1 rules in your packet. This relates to when there is a PAC or a party or someone else is spending money on a communication to voters. They do not explicitly ask for a vote for or against them, but it references a candidate. That is an independent expenditure that requires a financial report with our office unless the person comes forward and demonstrates that they did not have a purpose of influencing the election and that the communication would have an effect. So the question is just how does the commission go about making a determination of whether that influence was purposeful and present? So the changes that I made were since your last meeting. It's on page 6 of those rules at the bottom. Commissioners wanted standard to be the same, that the expenditure did not have a purpose of or would not have an effect of influencing the election. I don't want to keep rattling on if any of you are not seeing the pages that are relevant, but so that we made that change. The chair also pointed out that there was an extra reference to a provision that was no longer in the rule, so we eliminated that. The focus of the discussion last meeting was there's this procedure where someone can ask for a determination of the executive director whether the communication had a purpose of or an effect of influencing an election, and then they can appeal it to the whole commission. And the concern was, could someone who did not want to file an expenditure report take advantage of that process to sort of delay the filing of the report? So we made some changes in the proposed rule to address that. In subsection G, the rule would now say, if it was adopted, persons requesting a determination that no independent expenditure report is required are encouraged to submit their requests early, which I thought was consistent with what we wanted. Then going to paragraph H, if the commission makes a determination on the question of whether there's a purpose or effect of influencing the election, any person may appeal the determination. That subsection now reads that they only have a 2-day, that there's just a 2-day appeal period to file that appeal. So we would certainly work with anyone that felt aggrieved by this that we knew of to make sure that they had 2 days. There would be no secret if they wanted to appeal it. You know, we would be cooperative and helpful. And then in subsection I, what we changed I to say is that if the director or the commission makes a determination that an independent expenditure report was required and it wasn't filed by the correct deadline, the late filing procedures that you normally use would apply. And so there would be a preliminary penalty. They could ask for a waiver of penalty or they could pay it. Those are the normal procedures. So that would be the normal procedure. There was no grace period that they get after the final decision to file the report. It's like, if they're late, and they have to ask for a waiver of the penalty. But the way we wrote it, and we want to make sure you're comfortable with that, is that in the alternative, the executive director or the commission, for good cause, could extend the deadline of the report. That way, and I think I would personally use this sparingly, but if the commission or the director felt that they had a good reason for asking for a determination, they were acting in good faith, and they were late, and there was a preliminary period, it would be within your discretion or my discretion to say, okay, you get an extension. It's going to be considered on time. You do not have to go through this penalty waiver process. That was the thought process.
Yep, great.
Those are all the changes.
Thank you.
Yeah.
Any questions from commission members?
I'm just thinking through that last, what we just talked about, subsection I, and your ability to extend the deadline. And when that would happen.
When would we do that? I mean, under what circumstances
Yeah,
would we do
right,
that?
yeah.
Well, like I said, speaking for myself, I would use it sparingly.
Mhm.
In fact, I don't know that it's really necessary. We would prefer, we are not, when someone files a report late, that is, we don't grant extensions. We don't grant waivers. We turn it over to you. We don't feel that the staff should be empowered to grant waivers or extensions. This would be somewhat of an anomaly. We just thought I just threw that in there because I thought it might be efficient for you or for us. If someone just was obviously acting in good faith in asking for determination, they really believed that no report was due. But we decided there was a report that was due. We just thought it would save time for you and for us if we wait, if we could extend the deadline. But I think this would come up very rarely. So if that seems like more discretion than you want, we can just have the penalty procedures apply and we don't need an extension.
I'm just wondering, as a practical matter, if it invites people to ask, for everybody who's asked for a decision, and if found, no, you're wrong, and if we missed the deadline, didn't file, then ask for the extension. In any way that might otherwise happen. And then a related question is, if this provision isn't in there, it would still be within our discretion to waive it.
Yes.
So that's also making me think maybe we don't want it. I don't know.
I mean, that's been my concern,
Yeah.
and Jonathan and I, or Mr. Wayne and I have kind of run around with this a lot.
I would actually say we're not stuck on this at all. This
Right.
was really sort of give you
No, I appreciate it.
primarily the flexibility, and we could, if there's predominant feeling to delete it, then just get rid of it.
I appreciate it, and I appreciate the concept, and I do think could be circumstances that apply. I just don't want to invite a bunch of people, because presumably, hopefully, only people asking for determination that it's not an expenditure, they all have good faith. So I just don't want to open these floodgates to everyone saying, hey, we put in this request and it took them a couple of days to get back. I don't know, and that's my concern, and I think we have the ability anyway, so, but I don't want to be too.
And the underlying concern is with the independent expenditures is getting the information out to the public in a timely way.
Right.
That's the overriding concern.
So I
Where
guess
do
I'm
you land
thinking,
on
yeah.
I have landed with going with this language and seeing how it works out, seeing if maybe we get some useful comments in the comment period. But I could easily go with striking the provision that allows the director to extend the deadline.
How does it work procedurally with respect to going forward? If it's in there and we get comments and then we take it out and do more comments, like how does that work?
Yeah, there's, subject to the APA, I think if you get persuasive comments saying this should come out and you take it out, you probably would not need to, we'd have to look at it, but you probably would not have to re-promulgate and invite more comments. On the other hand, if you were just to decide on your own, not in response to a comment, to sort of, you've changed your mind, you want to take it out, then that changes things a little bit. You might need to do a second comment period.
Unless we do it now.
Unless you do it now, that's right. But the standard's a little bit different when you're responding to a comment versus when you just sort of change your mind after the comment period.
Yeah, that's exactly my question.
But we could do it now, and then that would be our
Correct.
the proposed rule.
That's right.
Yeah.
I don't know, what are the others think?
Anybody else have any
I don't have any real big
feelings either way?
I have just a couple of questions. we're dealing with section I, right, on page 7?
Correct.
Okay, so is there any benefit to, I guess my overarching comment is that does this just add to, I mean, everybody comes in with a reason. And, you know, some of them, I mean, on a, you know, kind of human level, there's many good reasons. So there's no definition here of good cause. Is it defined someplace else? There's also, what does a short period mean in this? And I guess my other question is, would people who aren't granted this come in and be able to come in and say, well, why weren't we granted this? I mean, does it add something to the, you know, people who are requesting waivers saying, why wasn't I given this? I don't know. I just don't understand. I'm concerned about what is a short period, and are we referring with good cause to some other provision?
I think those are good questions.
You do?
I'm leaning towards taking it out. I mean, I feel like I'm thinking in my mind when we might grant this, and I could see it being, we meant to tell you that you had to file an expenditure, and there was a typo in the email, and we said you didn't have to. Do you know what I mean? And then that's like kind of the only thing I could possibly think of, which I don't think would happen. And then I think we waive that.
Right, and I was gonna say, the commission still has the power to waive a penalty.
Right, yeah.
Even afterwards.
Yeah, I don't know. I'm thinking for some of the reasons you said, Sarah, maybe not having it, because we have the ability.
Can I ask a question? Am I on mute?
Sure.
So I could just keep focusing on the short period. I mean, are we talking about what does the commission staff consider? Are we talking about something like, you know, a few hours? You know, where we've seen a couple of those, a few days. How practically speaking, when do you think this might be used? As far as the short period, you know, sometimes people press a button 2 minutes after midnight or whatever. I mean, is that what we're talking about here? And would it be helpful to define what short period is? Or is that just?
I agree, but that's why I feel like if we get into that, then that seems like, which I guess is okay. I was gonna say, give people who made an early request more time. You know, if somebody presses a button and it doesn't go through and they're past the deadline, we penalize them for that. So I guess it gives people who made the request for an independent expenditure, potentially, if we grant this language, a little bit more leniency, which might be okay, because I think we want to encourage early requests. So.
And any kind of delay is the enemy of public disclosure, so. Right. Right. Commissioner Hastings?
If I'm kind of comfortable with the way it's written out, I have a lot of faith in the staff's handling of these kind of matters, and it's a dilemma that the person making the expenditure faces every time. Oftentimes these decisions get made very close to elections, and they have to pull the trigger or not, and they don't know if they're right or wrong. And this, I don't know, a system that encourages them to, I would think that the staff would treat a request differently if it was made 10 days after the expenditure was made and after the election versus, and it was wrong, as opposed to one that was made quickly. I think I trust the staff to take into account the totality of the situation and deal with it appropriately. It's a tough decision. Every time we deal with one of these, it's after the fact. And even though the request might have been filed before the fact, but we don't deal with it until the next regular meeting. And so I think this would be a solution. I don't ever recall us disagreeing with the staff's initial opinion as to the applicability of
An independent expenditure. Yeah.
So does the commission staff feel this would make things significantly or expedite some things that really they could handle themselves, basically, right?
Yeah, it was meant as a convenience for the commission members or for us. The one consideration that weighs on me is what I think I heard John say and our previous council say is that if you move forward with it, just in the interest of an efficient rulemaking process, if you move forward with this in and no one comments about it, which is likely, it's complicated for you to remove it at that point on your own volition, or at the very least, does it require another comment?
It may require another comment period, which is, it takes time, right? It's another 30 days that you have to put it after comment. It's not tremendously burdensome to do, other than you just have to wait the extra 30 days and file some paperwork with the Secretary of State.
That isn't really a big deal. I thought this would help, but I think frankly, it would come up rarely. So I think the benefit is very modest, to be honest.
We can also change the rule if it changes later, depending on what public comments are, and see if it actually is a practical hindrance or benefit. Right, I mean,
And I think we may be revisiting it depending on how it works anyway,
right, that's right, see how it
once
goes.
it's, once it's in place.
I'm okay with leaving it in for now. Or I say for now, depending on the comments, and I think
Sure.
that we should appreciate though that if we don't get comments. I don't see why I would change my mind next time around after any comments.
Right,
We're having
right.
this discussion now, so.
But we're not under a huge time pressure with these rules, so we could, if we wanted to, we could go through another comment period without any trouble. Commissioner Claire, what do you think?
I'm inclined to go along with Commissioner Hastings' comments on this. And so,
Okay.
I do have one question is, no, never mind.
No, go ahead.
No, that's fine. I'm done. Thanks.
Okay. All right, so I'll move that we move ahead with the rulemaking on these issues, the way that they're printed. Is there a second? Second. It's been moved and seconded that we move ahead with the rulemaking process. Is there any discussion amongst commission members?
No, just thank you all for letting me think
No.
about, think through it.
And those are the exact same kind of things that Mr. Wayne and I have been talking about, so. Thank you for bringing it up. Okay, hearing none, let's move to a vote. Commissioner Newman,
Yes.
Commissioner Marvin,
Yes.
Commissioner Hastings,
Yes.
Commissioner Leclerc,
Yes.
and I'll vote yes as well. Okay, moving on to the next matter. First, I want to kind of explain a little bit why there is an extra attorney at the table here. These are enforcement matters that we're going to be moving to go into executive session to discuss. And the potential exists for Mr. Bolton to be in a position to represent or advocate for the position that the staff has taken. And so we hired Mr. Terrison to be the counsel to the board in these matters, so that there's not any potential conflict of interest between the board's interest and the potential enforcement actions that are potentially in the future that Mr. Bolton would represent. Is that a fair?
Yeah, that's correct. And the reason that this was necessary is actually between when the investigation began and now, there was a law court decision called Narrowitz that kind of changed the what was our office's understanding of the rules surrounding this issue, and which basically requires that there be two counsel involved whenever there's a potential for an advertorial proceeding.
And so henceforward, in this matter, Mr. Terrison will represent the commission and will advise the commission on legal matters. And thank you for your willingness to do it. It's great to be working with you again.
Glad to be before the commission.
Terrific. Okay, so the next agenda item consists of two related enforcement matters on which the commission has previously directed staff to conduct investigations. I note for the record that the commission has received a letter from Newell Auger, Esquire, requesting the commission to consider the agenda item in public session. Thank you for that request, and I direct that staff make that letter a part of the public record of consideration of this agenda item. Commissioner Newman has an issue to bring up.
Yes, on this matter, I want to disclose on the public record that in my capacity as a private lawyer, I represent an individual named John Plummerfelt, whose name appears in this matter in a tangential way. I am noting this in an abundance of caution. My representation is entirely unrelated, and I do not intend to recuse myself.
Thank you very much. I recognize that under Title I of the Maine Revised Statutes, Section 401, quote, public proceedings exist to aid in the conduct of the people's business, unquote. And pursuant to Title I, Maine Revised Statutes, Section 402, Paragraph 2, the meetings of the commission fall under the definition of public proceedings for purposes of freedom of access. I further recognize that it is declared public policy that the commission's, quote, actions be taken openly, unquote, and that the records of its actions be open to public inspection and its deliberations be conducted openly before the general public. Nevertheless, I'm also cognizant that under Title I, Maine Revised Statutes, Section 402(3)(a) and B, records that are in the custody of the state agency or public official are accepted from the definition of a public record if they consist of records that have been designated confidential by statute or consist of records that would be within the scope of privilege against discovery. Further, Title 21A of the Maine Revised Statutes, Section 1003, Paragraph 3A, specifically provides that, quote, investigative working papers of the commission are confidential, unquote. My understanding is that this agenda item directly concerns such confidential investigative working papers. Moreover, I'm aware that under Title I, Maine Revised Statutes, Section 405, the commission may hold an executive session provided that the session not be used to defeat the purpose of the declared public policy that actions be taken openly, an official action not finally approved at an executive session, the executive session be called by a public recorded vote of 3/5 of the members present and voting. The motion to go into executive session must indicate the precise nature of the business of the executive session and include a citation to one or more sources of statutory authority that permits executive session for that business. Matters not identified in the motion not be considered during the executive session, and that deliberations and discussions in executive session be limited to only information contained in records to which access by the general public is prohibited by statute. While I certainly understand the request to consider this agenda item in public session, Maine law specifically provides that investigative working papers to commission are confidential, although the commission has some discretion to disclose such papers for specific purposes. I anticipate this agenda item will result in discussion of such investigative working papers that, at least in the first instance, should be treated confidentially as the statute generally provides. So consistent with the statutory provisions which I've just referenced, I would entertain a motion to go into executive session. Actually, I'll make a motion that we go into executive session under the provisions of 1 MRS Section 405(6)E through F and Section 1005 for the purpose of discussion and permitted deliberation upon investigative working papers of the commission in these matters made confidential by 21A MRS Section 1003(3)A. Is there a second to my motion? Okay. It's been moved and seconded that we go into executive session for the reasons that I stated. Is there any discussion? Commissioner Newman? Yeah, I met Commissioner Leclerc. Is there any
Yes. Oh, no discussion.
Okay, great. Hearing none, I'll call for a vote. Each member of the commission should indicate your vote as in favor, opposed, or abstain. Commissioner Newman?
In favor?
Commissioner Marble? In favor. Commissioner Hastings,
In favor.
Commissioner Leclerc,
In favor.
and I am also in favor. It's 5-0, supporting the motion to go into executive session. So at this point, I would ask that Mr. Wayne supervise the clearing of the room, and we'll go into an executive session. Sarah, can you hear us?
Yes, I can.
Terrific.
Okay.
Okay, I'd like to reconvene the public session of the Ethics Commission. And I'll start by saying that we had an executive session to consider some investigatory matters. Present during the executive session were only commissioners and staff and the Assistant Attorney General and outside counsel. No one else was present during the executive session. So at this point, would anybody like to make a motion?
Move to adjourn?
Is there a second?
Of course, there.
And this motion is not debatable, so we'll move directly to a vote. Commissioner Newman,
Yes.
Commissioner Marvel, Commissioner Hastings,
Yes.
Commissioner Leclerc,
Yes.
and I'll vote yes as well. We stand adjourned. Thank you.
Very good.
Is it that
Yeah,
motion to adjourn or not?
that was great. I can't believe how much work we've done. The more I look at rational.
It's impressive.
90%. A lot of people contributors, especially
Especially
early on, but we lost 2 employees in the course of this.
Right.
After writing the report,
Right.
I got a lot of feedback, but
Yeah.
I can remember when we had that session.